Good evening. My name is Robert Lewis, Chairman and co-founder of the Sino International Professional Advisory Council, or SIPAC, and in Chinese, SIPAC. We welcome everyone to join us for tonight's webinar. This is the second in a three-part series that we are holding this week on the three key jurisdictions of Eurasia. So once again, we have our friends at the ALRUD law firm in Russia. We have our friends at AEQUITAS in Kazakhstan and our friends at Azizov and Partners in Uzbekistan. Our Monday night program addressed issues relating to data privacy protection. And tonight, the topic will be doing business in each of these jurisdictions. On Friday afternoon, China time, we will have presentations by the same three firms for the same three jurisdictions on natural resources and infrastructure projects. So tonight we're very excited, again, as mentioned, to be able to have our guest presenters to instruct us and share with us information about doing business in their respective jurisdictions. Now, first of all, I'm happy to introduce once again Maria Ostashenko. I believe that she will be joined shortly by another colleague, and Maria can introduce him when he joins. But let's start with Maria from the ALRUD firm, which is a firm that we have known for many, many years, and I've had long-standing cooperation relationship with, and we're very good friends with them. And they are the one of the largest independent law firms in Russia, but as I understand it, it's also the only law firm in Russia where all of the lawyers are multilingual and are engaged in international foreign-related legal work. So they have the largest team to support foreign investors and other companies from China and elsewhere in Russia. So Maria, please.
Hello, everyone. Robert, thank you for your kind introduction and a few words about ALRUD. I'm glad to present today the Russian part of doing business. It will be of two actually sections, corporate and commercial. Just a second, I will start sharing my screen. Okay, can you see my screen?
Not yet. Just
Not
waiting.
yet?
No. First of all, we can welcome Boris now that he has joined. And Boris will be able to introduce himself when Maria hands over to him.
Yeah, it will be two of us. Robert, just tell me when you see the screen. It will be two of us. I personally do advise clients on things like entering the market and entering into different types of commercial contracts, being a commercial lawyer. And Boris is a senior, is an counsel in my team, and he also does quite a lot of work relating to customs clearance and things around customs regulations in general.
Okay,
Robert,
we still don't see, we don't see our PowerPoint yet.
Okay.
So maybe you can try one more time.
Yeah, let me try again.
Boris, while we're waiting, maybe you can just further introduce yourself.
Yes, thank you very much for this opportunity to give
our
Not yet,
presentation.
No.
My name is to hear me?
It worked last time.
Yeah, Boris, go ahead. Introduce yourself.
Okay.
That's fine.
Okay, so by way of introduction, my name is Boris Ostroukhov. I'm of counsel at ALRUD law firm. I'm a colleague of Maria, and I'm the member of commercial law practice dealing with
Can you see it?
commercial contracts and
No.
Uh, let's see. We had great success last time. I'm wondering if it's. I don't think you've sent us the PowerPoint, so I'm not able to share it at this end. I'm assuming that
maybe your colleagues at SIPAC have.
yeah, let me
Because
see. Did you send that to us?
Yeah.
Yes, our marketing manager sent it.
Should we change the sequence so that Tair maybe present on Kazakhstan and while we are fixing
Right.
this
Why don't we do that?
sharing issue?
Okay, that's fine. Tair, are you able to start now and share your screen, and then we will sort out the PowerPoint?
Yeah,
Sorry
I'll
for
try.
that.
Okay, no
I'll
worries.
try.
Okay, Tair is a partner with our good friends at the AEQUITAS law firm, and now we can see his slides working well as it did for everyone last time. But anyway, Tair, go ahead and make a brief introduction of yourself and the firm, and then go ahead with your presentation.
Okay, thank you, Robert. Good evening, everyone. My name is Tair Kulteleev. I'm partner with AEQUITAS law firm, and I'm focused on corporate law and registration of legal entities in Kazakhstan. And all my life, I'm assisting come to Kazakhstani market, and my clients from all over the world. And now I see a lot of interest from Chinese clients. So, and thank you for joining us. And my today's presentation will be about doing business in Kazakhstan and the establishment of legal entities, both in the main jurisdiction of the Republic of Kazakhstan and within the Astana International Financial Center, AFC, as well as the procedure of hiring of foreign laborers in Kazakhstan. These topics are essential for investors and companies looking to navigate the legal and regulatory environment of Kazakhstan effectively. Whether you are exploring opportunities in the country for the first time or expanding your current operations, understanding these frameworks will help ensure a smooth and compliant entry into the market. So let's begin our presentation. Before starting the registration process, it's important to decide on two things: the legal form of your future entity and where you want to register it. Kazakhstan has a unique regulatory model: one country, two systems. Alongside the general jurisdiction, we also have the AFC, the Astana International Financial Center, which operates under its own legal system based on English common law. The AFC was created to help attract investment into Kazakhstani economy and to develop our capital markets and financial service sector. In general jurisdiction, the most common legal form is a limited liability partnership, or LLP. In the AFC is private company, or LTD. Both are very similar to an LLC. Kazakhstan general place no restriction on foreign ownership of companies, except in a few sensitive sectors, such as telecommunications, private security, and mass media. A foreign company can also register a branch or representative office. Under Kazakh law, these are not separate legal entities. They seen as part of parent company located outside its main place of business. If you register such a structure in the AFC, it will take form of recognized company. So let's go to statistics. As of today, around 3,550 private companies have been registered in IFC. It's worth noting that 70% of all companies registered in the IFC are companies with Chinese participation. We have observed a significant increase in interest from Chinese investors, particularly following President Xi Jinping's state visits in 2024. In total, he has visited Kazakhstan 6 times. Currently, Kazakhstan and China are jointly implementing more than 100 investment projects, and over 5,000 companies from Chinese capital are successfully operating in Kazakhstan. In today's dynamic global economic landscape, these developments highlighting Kazakhstan's responsibility and reliability and attractiveness as an investment destination for China. Over the past 18 months, Kazakhstan and China have held several large-scale investment events, resulting on signing 150 commercial agreements worth over 50 billion USD. We warmly invite new Chinese investors to explore opportunities for collaboration. In this slide, you can see that in Kazakhstan registered more than 500,000 organizations in general jurisdiction, and majority of which are in forms of LLP, which I mentioned. So what makes the IFC attractive for foreign investors? First and foremost, it offers a unique legal environment based on the principles of English common law. This gives companies the flexibility to structure their internal documents and corporate procedures in a way that aligns its practices familiar in their home jurisdictions. The AFC also provides tax incentive for its participants that at the same time, companies from non-financial sectors, such as trading, holding, or general businesses, are also welcome to register in the AFC. However, they do not receive tax benefits except for exemptions on dividends. Another key advantage is in that the AFC allows company to hire foreign employees without any quotas or limits. It also provides a comfortable language environment, as English is the official language used for all businesses and legal matters. Tax and custom benefits on investors and for investors are not limited to the AFC. The general legal system of Kazakhstan also offers various incentives through the framework of special economic zones, or SEZ, and industrial zones. Currently, there are 14 SEZ across Kazakhstan, each focused on development specific sectors of economy. To qualify as the special economic zone participants, a company must carry out an approved priority activity, which typically includes manufacturing and production of finished goods. In addition, investors may also be eligible for individual incentives if they implement an investment project and enter into an investment agreement with the authorized state body. The minimum investment requirement to qualify is $15 million. So how to establish the company? In LLP, the charter capital is divided into participation interests. A participant contribution may be disproportionate to their ownership interests. The number of votes may differ from the ownership of shares. Profit of distribution is carried out in accordance with the ownership share. In LTD, in AFC, the charter capital divided into shares. In this case, shares do not refer to shares as in joint stock company. The structure allows to issue a different classes of shares with varying rights related to voting, dividends, etc. This slide shows requirements for company names. We won't go into the details right now, as the presentation, I hope, will be shared with all participants after the session. In these slides, we see information about legal address. Kazakhstani general jurisdiction LLP can use a legal or registered address. However, if the company is not actually present at the address, it can be listed as an unreliable taxpayer and may be disregistered from VAT. The situation in the AFC is similar, but keep in mind that a registered office must be physically located with the AFC zone. And for regulated activities, a real functioning office is required. Government structure of an LLP usually has two levels, as shown on the slide. In contrast, a private company in the AFC typically has a three-tier structure that includes a board of directors or a sole director. However, directors do not serve as executive bodies and are not required to receive salaries. But executive body is a chief executive officer, which must have salary and labor contract. The minimum charter capital for both LLP and AFC private companies is 0. However, if the capital exceeds $500,000, registration with national bank or other relevant authority may be required. For companies, shareholder information must be submitted to the registrar. This data will be publicly available on Kazakhstani e-government portal. Ultimate beneficial owner information is also provided to the registrar, but this is not published on public sources. In AFC, there is an extra step. Video verification is required for the director, shareholder, and UBO to confirm their identity. An LLP cannot have its sole participant another business partnership that consists of only one person. This rules applies in general jurisdiction, but it does not apply in the AFC. AML STF compliance officer is a person responsible for ensuring the company follows anti-money laundering and counter-terrorism sanctioning and financial laws. For this role, it's mandatory for regulated businesses. In AFC, this officer must be appointed at the registration stage. He must be a Kazakhstani resident, and he must be approved by the registrar. When we compare the registration process for an LLP and a private company in the AFC, the LLP is generally faster and much cheaper. To register an LLP, you only need 3 documents as shown on the slide: application form, extract from shareholders' commercial register, and power of attorney for local representative. In contrast, registering a company in AFC requires all of that plus a resolution to incorporate the company's charter, passports of directors and beneficial owners, CO, resume, a corporate structure chart, and several additional application forms. One difference worth noting that for LLP registration, all foreign documents must be apostilled and translated into Russian and Kazakh. In AFC, this requirement doesn't usually apply. This is not a major obstacle, and we will take a closer look at the registration steps on next slide. If the registration of the LLP is an individual, if the founder of the LLP is an individual, there are few more steps involved. They must be physically presented in Kazakhstan, have a Kazakhstan individual identification number, EIN, but EIN, this is not tax ID. And the founder also need to hold a C5 visa. This requirement doesn't apply if the founder is a legal entity. And they also don't apply in all FC situations, regardless who the founder is. For the timing, registering an LLP takes just 1 business days. Registering a private company in AFC can take any time from 5 business days to 3 months, depending on complexity. If the applicant is subject to strategic fit procedure in the AFC, there are few additional steps involved. The client must prepare a business and financial plan, a staffing plan, and obtain a legal opinion from a law firm confirming the results of sanction screening. The registrar may also request an interview with applicant, shareholders, or directors, and any other documents at their discretion. As for government fee, in Kazakhstani general jurisdiction, registering an LLP is usually free of charge. In the AFC, the registration fee is $300. However, once registrar reviews the submitted documents, they may impose an additional fee for the supplementary fee, which starts at 3,000 USD and may be higher depending on case. In Kazakhstani general jurisdiction, licenses are obtained after a legal entity is registered. In AFC, the process is different. Before granting a license, the registrar first issues an in-principle approval. These steps ensures that the applicant is credible and an experienced company that can be safely provide financial services without posing any risk to public. For startups, the AFC offers a special sandbox regime, the FinTech Club. However, this regime comes with certain limitations, and once testing is successfully completed, the company may be transitioned to the full regulatory regime. The state fee for obtaining a license in Kazakhstan general jurisdiction starts at around $50. In a contrast, a license in the AFC starts from 5,000 USD dollars. In addition, AFC companies are subject to an annual supervision fee, which starts at 1,000 US dollars. As for timeframes, in general jurisdictions, a license is usually issued within 15 business days. In the AFC, the process may take anywhere from 6 months to 1 year, depending on case. And now we go to the last section, which is foreign labor attraction. All foreign employees, whether they are physically in Kazakhstan or working remotely, must obtain an individual identification number, IN. As for work permits, these are generally required for all foreign employees, except in the following cases: citizens of Eurasian Economic Union member states, first executive of branches or representative offices, CEOs and deputy of CEO of Kazakh legal entity with 100 foreign ownership, employees working under the Astana Hub or within AFC, and few other specific exemptions. Kazakhstan also has a quota system for hiring foreign workers. The quota is set annually by government, and at least 70% of company total workforce must be Kazakhstan nationals. Under Kazakhstan immigration legislation, foreign nationals are generally subject to a visa regime for entry and stay. Chinese citizens, for example, can enter Kazakhstan visa-free for tourism and business visits for up to 30 days, and from Hong Kong up to 14 days. However, visa-free regime entry does not grant the right to work on register or to register a company. As mentioned earlier, if a physical or natural person is registering a company, they must obtain a C5 visa, which is a business immigrant visa. To work in Kazakhstan, a C3 work visa is required. is if a foreign employee does not physically enter Kazakhstan and works remotely from abroad, a work visa is not required. However, in the AFC, it's important to consider the substantial presence rule. This rule requires that a licensed company must have a real physical presence and genuine operational activity within the AFC's territory. And at this final slides covers the mandatory notifications an employee must make when hiring foreign workers. The host company is required to notify the immigration authority, the employment authority, and IFC administration if applicable. In addition, information about an employment contract must be entered into the Unified Labor Contract Accounting System, a national employment register. Thank you very much for listening.
I needed to unmute there. Tair, thank you so much for that. I often, when we do these webinars with multiple presentations by different countries, I will wait till the end and have questions then. But I think it might work best if I ask you some questions now while we're all thinking about your presentation. One issue that occurred to me was that UBO, ultimate beneficial owners issues, can sometimes be a bit sensitive or problematic for some Chinese companies, but maybe that's more of a problem in some other jurisdictions. Do you find that Chinese investors are concerned about disclosing the ultimate beneficial owners when they are setting up entities in Kazakhstan?
First of all, I want to answer this way. Yes, we can see that some clients, it doesn't depend on the countries, can be China or any other national, can be a bit worried about disclosing ultimate beneficial owners. But this is a law and it should be observed. And as I mentioned in the presentation, not any information about UBO will be disclosed in public register. So this is only internal information to registrar.
So that's an important element, and that can be helpful. But sometimes we also see that, and this can be particularly true for some Chinese companies, but it's not just companies from China, as you say. Sometimes there will be an interest in trying to avoid either limitations on foreign investment, et cetera, by having a nominee shareholder arrangement. So sometimes a Chinese party will do what's called a daichi, which is to have someone holding the shares for them. And so often they might have a local national who's registered as the owner, and there's some sort of contractual relationship about the actual benefits of ownership. So does the definition of UBO actually include that type of arrangement as opposed to just the multi-tiers of ownership up the chain? So what I just described, the nominee shareholder, would that be captured by this UBO concept?
First of all, I can answer that in general jurisdiction of Kazakhstan, we don't have such concept of nominee shareholders. But of course, we can use this type of concept, and this is quite common when one natural person can serve as a nominee shareholder with some certain arrangements with a real beneficial. And of course, in this situation, for our registrar, we will not need to disclose information about real UBO, and information only of natural person will be submitted, and by registrar counted as he or she is UBO. In AFC, we have such concept as a nominee shareholder, and the nominee shareholder can this service can be provided only by firm accredited by AFC to provide in such services. In general jurisdiction, there is no such concept, and that's why anybody can serve as nominee shareholders.
All right, understood. So I think you said this earlier, but can you explain again what percentage of, in your experience, what percentage of Chinese companies are going into the general jurisdiction in Kazakhstan and which are going to into the AIFC?
In AFC, I counted because it's public database and you can easily find who is a shareholder, and approximately 70% of 100 is companies with a Chinese participation. In general jurisdiction, we have public database, but there is so many companies registered every day, so there is no such statistics.
Okay, now that's very interesting to know. My last question is about employment, because this again can present some issues, or at least it has historically. For example, it's one thing to set up a company, but if, for example, if a Chinese company is a prime contractor in an infrastructure project, many times they will want to bring Chinese workers in to do the work. Or another situation where maybe where you have some other major equipment that's being installed or serviced, and sometimes the Chinese company will want to send in Chinese employees, technical employees, to come and provide the service or the installation. And I am aware that there have been situations in the past, it may be improving now, where the Chinese companies have not always complied with the rules restricting work when people come in on these other arrangements. So do you see those types of issues arising with foreign employees who come in to do installation or maintenance type services?
I think you are talking about situations when Chinese companies working in Kazakhstan, which is maybe even registered as the legal entities in Kazakhstan, but with the Chinese participation, not observe these rules. In which situation they cannot observe this rule? If they conclude an investment agreement with the Kazakhstani government, in this case, our government provide all exceptions for them. For example, currently, China assisting Kazakhstan to build LRT. It's a major infrastructure project in Astana, in our capital, and there is 100% Chinese nationals working on this infrastructure project.
Oh, that's very helpful. Thank you very much, Tair. It's very good to see you again after meeting you in Hong Kong, I think late last year or earlier this year. But anyway, it's thanks so much for your presentation. All right, I think we can now turn to Maria again. Maria, if you can try again to share your slides. If not, I can share from here.
Yeah, fingers crossed it will work. If not, then I
There we
will
go.
need your
Here it
help.
comes.
Oh, great.
Excellent.
Okay, I will not introduce myself again. So my presentation will be divided into sections, as I mentioned, corporate and commercial. And I will start with the corporate side, very similarly to what Tair presented regarding the forms of legal presence in Russia. Here we have quite a variety of different options for companies to enter the market by corporate means. So you see on the slide different types of corporations available, like a menu. The most common is limited liability companies because the rules around this type of legal entity are much more flexible and convenient for businesses. So if you see in the whole pool of legal entities, 99%, I would say, would be LLC, so-called LLC. Some companies should be arranged in the form of joint stock companies, but I would say that that's merely an exception. So all companies should be registered. I think this rule applies actually to every jurisdiction. We have a public register of legal entities. For some activities, companies should have special licenses. For instance, banking activities, insurance, and so on. Construction sites should have some permits, and sometimes companies should participate in self-regulatory organizations. For instance, construction companies. In terms of the documents, usually legal entities have charters or articles of associations. So the main corporate document where you stipulate rules of organizing the company, corporate governance, and such major things around corporate life. For many foreign businesses, the main question regarding the form of presence lays in the format of whether to open a company or subsidiary in Russia or to open, for instance, a branch. Branch is very similar to LLC in terms of what is permitted to do. With a branch, it's a subdivision of a company which is authorized to do commercial activity. And this differs from the representative office because representative office is not allowed to do commercial activities. But apart of that, here on the slide, you see a kind of summary of what is the difference. And here you see that LLC, for instance, is an independent entity, so it acts on its own behalf, while a branch is always acting on behalf of its parent company. In terms of the liability, as it follows from the name, limited liability company has some limitations with regard to liability of its parent company. It doesn't mean that parent company is not liable at all. In some cases, there are rules about the subsidiary liability or even joint liability of parent company. But generally speaking, LLC is like a separate entity. It is liable for its obligations before the creditors. While with the branch, your parent company will be directly liable for any transactions done by the branch. With that, I would say it's more or less similar. Non-taxable profit repatriation. Here, of course, we have rules on dividends taxation, and LLCs and shareholders are subject to those rules, of course. While with a branch, as soon as there is no actually distribution of profits with a branch, it's just all the assets owned by the branch are actually owned by the parent company. So there is no such tax issue as dividends. Regarding the establishment process, very briefly, the process is quite straightforward. It's not 3 weeks as in Kazakhstan, but still, it's not a very lengthy process. There is some bureaucracy around establishment. For instance, if you want to establish an LLC, someone from the parent company authorized should come to Russia in order to appear before the notary. And referring to your Robert's question, regarding UBOs, now due to some counter sanctions regulations, companies should indeed disclose UBOs in order to show that the shareholders of intended LLC are from friendly jurisdictions or unfriendly jurisdictions. In the second case, there should be a government approval for establishment. So there is another level of bureaucracy for establishment. With that, what else should be kept in mind regarding the entering the market through corporate vehicles is that we have obligatory reporting obligations that cannot be anyhow ignored or omitted. So there are reporting documentation that should be submitted to the tax authorities like every year, quarterly, depending on the taxes. There are requirements regarding annual shareholders meetings that should be done like annually. Another thing is address. I think Tair also touched that there should be an address of the company, and to this end, some arrangements should be with the landlord in order to provide the address to the company. Bank is an issue because majority of Russian banks currently are sanctioned, and there are a lot of challenges regarding payments. So plus there is some certain level of bureaucracy regarding opening an account with a bank. So it's also one of the issues. And executive person. We likewise in Kazakhstan, in Russia, we don't have too much developed concepts of nominee, nominal directors, and so on. So formally, it should be a real person who is responsible for the activities, and you need to be quite careful regarding this issue. Because it's really a person who represents the company, can act on its behalf, and so on. So to sum up some major things also regarding setup, as soon as many Russian banks are sanctioned, issues around money movement should be thought of in advance. Because it goes with the vitality of the company. Also, it should be noted that recently there were changes around bankruptcies of foreign entities. They were not available before, but now a foreign entity can be regarded as bankrupt in Russia. And this leads to the question regarding branches, because it is possible that a branch can be qualified as bankrupt under the Russian laws, and the assets can be then disposed according to bankruptcy rules. And another issue is counter sanctions. Many Western companies are very much restricted in terms of setting up business in Russia. So this question should be also analyzed every time when you enter the market, for instance, with some partners, or there is someone from, for instance, EU in the chain of ownership of, for instance, Chinese company. With that, I would pass the word to Boris. Boris, do you want me to continue sharing? I will just change the slides. Yep. Okay.
Yes, Maria, thank you. So hello everybody again. I will continue Maria's presentation. We'll speak about the transactions in Russia. We can switch to the next slide. Why we chose to speak about the transactions? I think the reason is quite simple. The transactions are, well, maybe the most important for the companies after they are established, because of what the companies are doing, they're entering into transactions and making the transactions. We have quite a lot of classifications in Russia of the transactions. On this slide, we are illustrating maybe the main classifications which are necessary for businesses. So we have unilateral, bilateral, and multilateral transactions. By way of the example, unilateral transaction maybe is a power of attorney issued by a company to a third party. An example of bilateral, multilateral transactions can be maybe any contracts like two-party contract or multi-party contract. As a general rule, all the transactions should be made in a simple written form, not necessarily just in paper. They can be made electronically. I mean, for example, by exchange of scan copies. In cases stipulated by law, or if the party agrees on that, the transactions can be certified by the notary, and this is what we're calling a notarized written form of the transactions. And there's also an option to make an oral transaction, but this is still quite rare and maybe inconvenient in terms of evidencing about what the parties agreed in oral transactions. So the scope of oral transactions is quite limited. And maybe the last classification is conditioned and unconditioned transactions. This basically means that the parties are able to agree on that entry into force or performance of certain obligations under the contract can be conditioned to something, to some circumstances or something like this. This is used in practice and quite convenient for the parties if they need this instrument. On the next slide, we are demonstrating, we're basically moving to the contracts, to bilateral or multilateral transactions. On this slide, we are demonstrating what types of contracts are provided for in Russian Civil Code as basic concepts like sale and purchase, representation, contracting or development, carriage or transportation, insurance, lease or rent, loan or credit, storage, and there are actually many others. In terms of Russian civil and business law, the parties are entitled, so they are entitled to enter into so-called mixed contracts, which have elements, for example, of sale and purchase and representation agreement, or sale and purchase and carriage agreement. So this is also quite common and quite convenient. The distribution agreement is also a good example of a mixed contract when the parties agree on various obligations not related merely to sale and purchase, but also some accompanying obligations. What can be important for foreign companies, maybe for Chinese companies, is that the parties, if a contract has a so-called foreign element, like a Chinese party in a contract with Russian party, then the companies are able to agree on the law applicable to the agreement. They can choose either Russian law or any foreign law, for example, Chinese law. If the parties do not agree on the applicable law, then the parties can go to the civil code, the Russian civil code, and see what law will apply to such contract by default. For example, if we are speaking about sale and purchase agreements, by default, the applicable law will be the law of the seller. So it will be, most frequently, it will be Chinese law applicable to the agreement with Russian buyer. And maybe one more thing important for application of foreign law and for choice of foreign law is that the parties should, while formulating the terms of the contract and agreeing on the choice of applicable law, the parties should take into account that there is a public order, some basic public rules that should be observed by the parties in the agreements or when performing the agreements. This means that if the parties agree on something which contradicts to the public order or public policy, such terms of the agreement will be unenforceable, and the parties will not be able to enforce them in case there is any dispute related to that provision. By way of example of how Russian law regulates the contracts, on this slide we are providing the brief description of regulation of the supply contract. Sorry, supply contract is a sales contract, but for specifically dedicated to the relations between the business entities, like companies or individual entrepreneurs. We cannot say that there is really great specific, so I think that's in Kazakhstan and other jurisdictions, so the regulations are pretty similar. But what may be notable here is that Russian the practice of contract, if I can say so, recognizes that the contract can be made not only in one single document, but the parties can use some instruments like terms and conditions, which is a separate document when the parties can just consent to the terms and conditions and consider that they are entering into a supply contract. They can, the parties can agree on a mixed contract, which will include the terms of the supply contract. So the supply contract in Russia is, let's say, some basic instruments for sale and delivery of the products, are quite convenient and can be used as it is or as a part of a more complex contract if the parties would like to enter into such type of contract. And on the next slide, we have basically a similar example, but related to the service contract. This is also an example of some basic regulation in the basic contract, which the parties can use either as it is or as a part of the more complicated agreement. Unlike the supply contract, the service contracts give a bit more flexibility for the parties in terms of the termination of contract, because as a general rule, the service contract can be terminated by either party for no reason and at any time. Picture that may be useful to take into account is that the law prescribes the financial consequences for both the customer and contractor for such no reason termination. So for the customer, it means that the customer will need to pay actual costs incurred by the contractor, and the contractor will need to compensate the losses to the customer, which are relevant to the termination of the service contract. Maybe we can also add that in the contract work, we also have such concepts like indemnities, or Russian view on international concepts such as indemnities, and I think that many others worldwide worldwide known concepts, and the parties can use Russian law operating by the concepts and notions that are familiar to them. So I think I leave it here.
All right, thank you so much to Maria and Boris. Now, again, I'd like to ask you some specific questions. I'll start. Maria, why don't you display your contact information there on the next slide so people can take note of that while we're having our dialogue.
Pleasure.
To my knowledge, 5 or probably more like 10 years ago, a lot of cross-border transactions from outside of Russia into Russia, particularly involving financing, would probably be structured through Cyprus and under English law, because there was a general feeling internationally that Russian law was not as complete, not as reliable. But I know that even well before the circumstances of the last 3 years with the conflict in Ukraine and the sanctions and counter-sanctions, the counter-sanction measures, that there had been a big effort on the part of the Russian Federation to improve the overall legal system and the laws and regulations to be more comprehensive and complete. And so there was already a trend, as I understand it, to encourage the adoption of Russian law for cross-border transactions. Now, of course, we have all of the complicating factors. You've mentioned friendly and unfriendly countries. And so obviously, that will impact these structures. I understand that Cyprus is no longer a popular conduit for investment into Russia. The people will go directly, if I understand correctly. But also on the governing law, you mentioned, I think it was Boris who mentioned that you could choose Russian law or Chinese law, but could you also choose third country law? And in the current circumstances, if it's a Russia-China cross-border contract and you wanted to choose third country law, what would you choose?
Great questions. A bunch of questions, actually. Yeah, I can confirm this fact that the English law was very widely and very much appreciated by Russian lawyers, in-house and external counsels, actually, because of its flexibility and convenience. And it's still very much appreciated. So the Russian government really struggled to win this competition of different jurisdictions. And there was a reform like more than 10 years ago in order to stimulate more use of Russian law, given more flexibility to, for instance, corporate instruments, corporate agreements, and so on. So there was a big move in that regard, indeed. But I cannot say that English law is no longer a good choice. It's really not a good choice in terms of geopolitics, indeed. And because you cannot choose arbitration in London as it used to be. So what we see now is probably Russian law is much more popular now, forcedly or not forcedly. But still, many companies or many agreements are structured under non-Russian law. For instance, Hong Kong law is kind of substitute to English law, also quite flexible and good for some of the transactions, at least. Hong Kong arbitration or Singapore arbitration is very popular, like a replacement for LCIA some time ago. So coming to your question regarding choice of some third country law, yes, it's available. It's a valid choice, taking into account the rules that Boris mentioned regarding public order. So you cannot choose sometimes non-Russian law, or you should at least follow the Russian law concepts. With that, you can choose. As I mentioned, nowadays we see a lot of transactions under those jurisdictions, we see transactions under Chinese law and other neutral jurisdictions like UAE and some others, given some flexibility, non-available under some instruments of Russian law. It still have some deficiencies, I would say, in some cases, especially in complicated transactions like financing. It can be difficult to meet all the requirements under Russian law.
Well, that's a very helpful response. I was very interested to hear you mention that international arbitration in Hong Kong and Singapore would still be attractive. Obviously, that's very common for Chinese parties to select Hong Kong or Singapore. But I'm also very interested that you mentioned UAE, because obviously they are promoting their jurisdiction as a venue for international arbitration, and they also have significant investment in international legal resources. And as you know, in SIPAC, we have our member firm in the Middle East in UAE, the Al Tamimi firm, and they're very, very strong, very capable, and they also have a very strong international arbitration practice. Now, the other issue that we would love to spend time talking to you about, but we don't have enough time, is on the bank accounts and the payments. That's a very important issue, but it's a very big issue. We've discussed some of that with Maxime from your firm in previous webinars. So we'll set that aside, but we'll just note that in a lot of cases, in a lot of jurisdictions, setting up the bank account can already be a challenge. For example, even in Hong Kong a few years ago, the startup company had a very difficult time setting up a bank account because of anti-money laundering requirements and KYC requirements. But now, of course, in Russia, there will be even additional layers of complications and considerations. But we'll just flag that as a very important consideration, and we'll leave it at that for this presentation so that we can now move on and have our friends from Uzbekistan also come.
Thank you.
All right, thanks so much.
I will stop sharing.
That's right. Okay, now we're very happy to introduce Abdumalik from our friendly firm in Uzbekistan. So Abdumalik, perhaps you could briefly introduce yourself and your firm and share your slides if you have slides.
Thank you. Good afternoon, everyone, dear colleagues, dear participants. First of all, thank you for the opportunity to participate in this webinar. My name is Abdumalik Mukhtorov. I am a senior associate at Azizov and Partners law firm. Our law firm is situated in Tashkent and mainly serves international clients for commercial matters, including investments, project finance, and also company establishment matters. So I will share my screen now.
Okay, it should be coming shortly.
Is it visible to everyone?
We see that you have started to share your screen, but there it is now. Here it is. Thank you. Go ahead.
Okay. Today, I'll be speaking about doing business in Uzbekistan. And my presentation will consist of the following issues. I will speak about types of corporate vehicles available to foreign investors in Uzbekistan, incorporation of a legal entity, registration procedure, regulatory approvals, regulation of foreign trade contracts, and I will briefly speak about tax matters and also special economic zones in Uzbekistan. So first of all, there are three types of corporate vehicles, three types of legal presence which are available to foreign investors in Uzbekistan. These are a legal entity, a representative office, and a permanent establishment. A legal entity is the most favorable option for most of the investors, investors due to its broader capacity compared to other two corporate vehicles. A legal entity is a fully fledged corporate vehicle which have general civil rights and can assume civil obligations, and also capable of carrying out all types of business activities. Then comes a representative office. Under Uzbek law, there are two types of separate divisions which a company can have outside of its place of business. The first one is a branch, and the second one is a representative office. The branch structure is not available to foreign persons, though it's not directly prohibited in the legislation. It's impossible for foreign companies to set up their branches in Uzbekistan due to the lack of regulation of this kind of vehicle. So the only available option is a representative office. A representative office is, as the civil code describes, a separate division of the legal entity located outside of its place of business, which represents its interests and protects them. But compared to branch, a representative office cannot carry out business activities. It can only protect interests of the company, of the main company, in non-commercial matters, and only can carry out marketing activities. And the third one is a permanent establishment. A permanent establishment is mainly a tax status, which is registered for the tax purposes, and it's usually usually suitable for a one-time activity. For example, if a foreign company wants to carry out a construction activities on the basis of a construction contract, then it will register its permanent establishment with tax authorities. So we can say that usually the permanent establishments will arise on the basis of commercial contracts. And if I talk about the incorporation of legal entities, it shares many similarities with Russian and Kazakhstan legislation, as my colleagues talked about. So main types of legal entities, commercial legal entities, are first joint stock companies, and the second is limited liability companies. In Uzbekistan as well, the limited liability companies are mostly widespread. The reason is that joint stock companies, first of all, issue stocks in stock exchange, and is subject to heavy regulation. They should disclose some of their information publicly, and also they should have a complex management structure. And that's why most investors prefer limited liability companies, because it does not require disclosing their information publicly, and also the management also can be simple. However, some types of activities specifically require setting up a joint stock companies. For example, banking activities or insurance companies can only be established in the form of a joint stock company. Regarding the charter capital of these entities, there is no specific requirement in relation to the amount of charter capital for both joint stock companies and limited liability companies. It can be nominally $1 or something like that. It's at the discretion of the investors. However, some license requirements in order to obtain some licenses, there could be some requirements regarding the amount of charter capital, but it's only for a specific type of activities, as I mentioned, banks or insurance companies. The registration procedure, I will mostly talk about the registration of legal entities, specifically limited liability companies, as it's mostly favored and mostly preferred by investors. But I can at the end briefly talk about the registration of permanent representative office and permanent establishment as well. In general, the registration procedure, the registration of commercial legal entities follow a uniform procedure for state registration with small certain deviations. As an example, I can talk about the procedure for the registration of a limited liability company with a sole founder through an authorized representative. Before registering a business entity, the founder should take some preliminary practical steps. Though it's not required by law, as a matter of practice, these issues could be necessary for the founder. First of all, the founder must identify a CEO and draft an employment contract with him. A sample, if you can access to my representation, I provided a link to the draft employment agreement as well. And then the founder should also identify a chief financing officer of the company. This can be the same person with the CEO. In this case, it's not required to determine as a separate person for financing or accounting of the company. But in some cases, companies prefer to have a separate accountant for the accounting of the company. And samples could be found in the link in my presentation. Then you should determine the location of a business entity. Why it's necessary? Because while registering a legal entity, first of all, the government authorities, the registering authority, asks for the legal address of the company, and also the cadastral number of the premises where the business entity will be located. So because the legal entity has not been established yet, it cannot conclude a lease agreement with the lessor, but there could be other options. You can find a lessor and get from him or her a guarantee letter, which is accepted by the registering authority, which provides for. Then you should choose the main type of business activity, that is business code for statistical purposes. This is only necessary for statistical purposes. Specifying the main type of business activity does not mean that you should only carry out this specific type of business activity. It does not limit the company from other activities, but it only will be required for statistical purposes. And in Uzbekistan, all types of business activities are coded, and you can choose from among these codes the relevant type of activity that you will be intending to carry out in Uzbekistan. And also you can prepare sketches of corporate stamps and seals, and you should beforehand select the servicing bank of the company where your main bank account will be opened in Uzbekistan. And also if you are trying to set up a business entity through an authorized representative, then you should issue a power of attorney to this representative as well. So once you have completed these practical steps, you can visit, or your authorized representative can visit the registering authority, which is called Center for Public Services, and the registration can be carried out there. In order to register a business entity, the certain documents need to be submitted to the registering authority. These are the decision of the sole founder in case of the company which is established by a single shareholder, or it can be the decision of the participant of the company, which approve the establishment of the company and also charter of the company. And the second is the charter of the business entity, and also a document certifying the identity of the representative, which is passport and also power of attorney. Then when you book the name, beforehand for the company, you will have the reserved name, and which is assigned a specific number. You will provide a specific number to the registering authority and cadastral number of the leased premises. Then you should also provide the personal identification number of the founder and of the CEO, if the founder is an individual person. If a CEO is an Uzbek resident, such a number is assigned to him or her at birth. But foreign individuals can obtain this number from this Center for Public Services in 15 minutes before registration. It does not take a lot of time, and the only thing that's necessary is the passport and the picture of the individual. And before registering the company, you should also pay the state fee for the registration, which is around $20. Upon completing registration, the companies can carry out their business activities freely. It's not required under Uzbek legislation to obtain a specific type of business, to obtain a general business license to carry out business activities, because the capacity of the company to carry out most of the types of business activities arises at the time of registration. However, some types of activities or actions may require some regulatory approvals. These are licenses, permits, and notifications. And most of such activities are either activities which may entail harm or damage to the life of citizens, or also can be detrimental or can cause damage to the rights and legitimate interests of individuals and legal entities, or which can be harmful to public safety. So in order to carry out such types of activities, it can be, for example, construction activities, which require obtaining a specific type of construction license. Then the specific licenses or permits or notifications are necessary. Licenses usually are issued for certain activities. Permits and notifications are issued for certain actions. All types of activities and actions which are subject to obtaining license or permits are unified in the same document, which is the Law of the Republic of Uzbekistan on licensing, permitting, and notification procedures. So if you are hesitant about your activity will require such type of license or permit, you can only find all the information only in this document. So it's quite simplified. And during its activity, usually companies carry out foreign trade transactions, and foreign trade operations are subject to specific regulation in Uzbekistan. Foreign trade operations, which are usually export and import contracts, should be recorded in the specific electronic system called Unified Electronic Information System of Foreign Trade Operations. This system is created for the purpose of foreign exchange and customs control. Without recording export and import contracts in this electronic system of the government, the contracts, the terms of the foreign trade contracts cannot be performed or cannot be enforced in Uzbekistan because it is connected to the system of most of the government authorities and banks, such as tax authorities and customs authorities as well. For example, if you are importing goods, then the customs clearance of the goods and also payment for the goods cannot be approved by the specific bank or by the customs authorities, respectively. And the existing economic policy generally restricts economic activities of Uzbek residents outside the territory of Uzbekistan. So I would say it's generally not allowed to, for example, carry out business activities abroad by being located in Uzbekistan. I mean, it's mostly in terms of the foreign trade transactions. For example, if you can buy goods in China, you cannot export these goods from China to, for example, other country, India, by being in Uzbekistan without importing these goods. Only the residents with exporter status are allowed to purchase products abroad and sell them directly to third countries without importing them into Uzbekistan. Then tax matters may also be interesting for you. In general, there are 10 types of taxes in Uzbekistan. These are, as you can see, value-added tax, excise tax, profit tax, personal income tax, tax for the use of subsoil resources, special rent tax on the extraction of mineral resources, tax for the use of water resources, property tax, land tax, and social tax. So I'll briefly speak about each one of them. Value-added tax, as is known to everyone, is levied on the goods and services imported into Uzbekistan, and also goods and services provided and sold in Uzbekistan. And the general rate for this tax is 12%. And excise tax is mostly for the dangerous goods, for example, alcohol or tobacco products, and its rate may differ depending on the type of the product. Profit tax, with regard to the profit tax, the standard rate is 15%, but it may range from 0 to 20% for certain categories of taxpayers. For example, for banks, it's 20% from the income, from the profit. And dividends are taxed at the rate of 5%. With regard to China, there is a double taxation treaty with China, between China and Uzbekistan, and also dividend taxation of dividends, and also commercial operations between China and Uzbekistan is subject to this double taxation treaty as well. Personal profit tax is for the legal entities. Personal income tax is for individuals. The standard rate for the personal income tax is 12%, 5% for dividends for residents, 10% for non-residents from the incomes in the form of dividends or interests. And also tax for the use of subsoil resources it's usually paid for the, as the name implies, for the use of the subsoil, some types of subsoil resources of the mineral resources of Uzbekistan, and the tax rate varies depending on the type of the research which is used by the business entity. And also there is a special rent tax on the extraction of mineral resources, which is 25%. And for the use of water resources, you should also pay taxes, and depends on the type of activity for which you will use the water resources, and also depends on the amount of the water that will be used in Uzbekistan. Property tax is paid only on the real property that is owned by the persons, and it's 1.5% for legal entities and from 0.34 to 1.5% for individuals. And also land tax will vary on the depending on the region where the land is owned by the entities or individuals. Social tax is paid on the basis of the salaries that are paid to the employees of the company, which is 12%, or which is at the rate of 12%. There are also special economic zones in Uzbekistan. Special economic zones, investors, it could be interesting for investors to invest in special economic zones because such zones are territories with a special legal regime created to attract investment and accelerate economic development. Such zones usually offer tax and customs incentives and also other types of benefits for those who invest in these zones and carry out their activities in these zones. Usually, such zones promote certain type of activities. For example, in a certain region, a special zone can be created for a promotion of leather industry, and the companies who produce leather products in a certain specific territory will be exempt and will enjoy the privileges and the incentives that are provided for this territory. And there are usually 5 types of special economic zones in Uzbekistan. These are pre-economic zones, special science and technology zones, which are created for the development of science and technology, tourism and recreation zones, free trade zones, and special industrial zones. So with this, I will conclude my presentation, and if you have any questions, I am glad to answer.
All right, thank you very much, Abdumalik. This was an excellent presentation. I have a couple of questions for you. It seems to me that the tax rates are already quite attractive. So what additional tax incentives are there in the special economic zones? And do you find that foreign investors tend to focus their investment activities in the special economic zones, or are they open to consider investment anywhere within the country, even outside the special economic zones?
Yes, usually in our practice, I will come across such issues. Usually investors tend to ask such questions due to the interest in special economic zones and also due to the interest in the incentives and benefits provided for such zones. And usually, if possible, they will try to open their business in such zones. Tax incentives and also other benefits differ from one zone to another. For example, if the president, with the presidential decree, they create a special economic zone for leather industry in Tashkent, let's say, and this specific presidential decree provides for the incentives for this specific territory as well. The incentives could be, for example, the decreased rate for the profit tax. For example, some economic zones may pay the profit tax at the rate of 7.5%, not 15%, but half of it. Or it can be it can exempt the companies from customs duties, customs payments for some products. For example, if there is a special science and technology zone, and the investor company is importing some technologies that are not produced in Uzbekistan, such products are exempt from, for example, customs duties or customs payments. I can't exactly remember what kind of tax benefits or tax customs benefits are provided for certain territories, but in general, the incentives will be in this manner.
That actually makes it quite attractive. So in your experience over the last several years, what are some of the main sectors that have attracted Chinese investment and business activity in Uzbekistan?
In my experience, I usually see Chinese companies investing in car manufacturing industries, and also mostly in infrastructure projects, such as the electricity power generation companies, and also other types of infrastructure projects. Mostly, I would say, in the energy sector and car production sector, I would say.
All right, my final question is just a point of curiosity. Obviously, there's a historic relationship in Central Asia and Eurasia with Russia, Soviet Union. How closely aligned are the legal systems of Uzbekistan and Russia and other Central Asian countries? Are you all civil code countries? And do you all have some similar legal tradition, or do you have unique histories for your legal system?
I would say that these countries mostly share many similarities with regard to their legal systems. And yes, almost all of the countries in these regions are civil law countries, and most of the legislation is codified. And also regarding the civil, from the perspective of civil law, it's also more or less the same. As far as I know, the Russian Federation has made some reforms in order to incorporate English law instruments to their civil code. If I'm not mistaken, starting from 2015, by introducing like English law institutions such as representation and warranties or indemnities. And Uzbek government has also made the same approach, but at a later stage, starting from the 2020s. So I would say regarding the overall regulation and the overall structure of the regulation legislation, and also regarding the recent trends and approaches, I would say that they are quite similar to each other.
All right, thank you very much. I see Maria has joined us again. Maria, do you have any comments on that?
No, I can only confirm that indeed, being in the past members of the same state, Soviet Union, of course, there are many similarities in terms of the tradition, of the legal tradition as well. I would not say that we have English law concepts too much in our jurisdiction. That's maybe Tair is much more aware with their very unique situation of having Kazakh law and English law in the same country. But for us, still it's quite as I said, English law is very much appreciated and or used to be very much appreciated because of its convenience, but still we are more European traditional legal system.
Right, thank you. Well, I'd like to just give thanks to everyone. And Tair, if you're still with us, if you want to make one last comment before we conclude, I'd certainly welcome you to do that.
I just want to thank everybody.
All right, thanks to all of you. We appreciate everyone who has joined us. This has been another outstanding webinar presentation by the leading law firms in these 3 important jurisdictions. I know on Monday night we had an outstanding group of Chinese lawyers online. We hope that tonight we did as well. It's been very, very instructive, and we look forward to Friday afternoon when there'll be a focus on natural resources and infrastructure projects in these 3 countries. We hope all of you will join us then. And until then, good night and thank you.
Thank you very much.
Thank
you very
you.
much.
Goodbye.
Goodbye. Bye.